Welcome back to the Deep Dive. We are really glad to have you with us today.
We've got a fascinating one for you.
We really do. We're going to tackle a subject that it sits right at the intersection of your daily life, your bank account, and some really high-level political philosophy.
It's one of those ideas that feels solid until you push on it.
It feels completely solid, concrete even. I'm talking about ownership. I mean, think about the narrative we're all sold, right? From the time we're kids.
Oh, yeah.
You work hard, you save up, you buy a house, you sign that, that massive stack of papers at the closing table, your hand cramps up from signing your name 50 times.
Been there.
And you pay that mortgage for 30 years. And at the end of all that, you think, this is mine. This is my castle. I can do what I want here, and no one can take it away from me.
That's the dream, isn't it? The American dream, the global dream, really. It's about stability.
Exactly. It's the foundation of modern security. The idea that you have a sanctuary, a place that's inviolable, where the world just stops at your doorstep.
But that's the thing. It's a bit of an illusion.
It really is. Because as we dug into the stack of research for today, and it is a massive stack of legal history and case law, it turns out that mine is a very, very flexible word when the government gets involved.
It's not as absolute as we think, not by a long shot.
So there's this legal superpower that governments all over the world have. It's a power that predates our constitutions. In some ways, it predates modern democracy itself.
It's the power to say, actually, we need that property more than you do.
We are talking, of course, about eminent domain.
Eminent domain. Or, depending on where you're listening from, you might know it as compulsory purchase.
Or resumption, expropriation, land acquisition.
It has a lot of names.
It does, and we'll get into why that is, because the names themselves, they kind of tell a story. But the mechanism is the same every time. It's the state taking private property for public use.
And we are not just talking about the government needing to build a highway through a cornfield. I mean, that's the classic example everyone learns in civics class.
Right, the textbook case.
No, the rabbit hole goes so much deeper than that. It's not just about infrastructure. It's about the very nature of the relationship between a citizen and the state.
It asks that fundamental question, doesn't it?
Yeah.
Does the individual exist for society? Or does society exist for the individual? And where do you draw that line?
That's the core philosophical tension we're going to explore.
So our mission today is to really unpack this philosophy of ownership. We're going to look at everything from, 17th century Dutch jurists who actually invented the terminology.
All the way to modern sports franchises. Yes, sports teams.
We have to talk about the sports teams.
Yeah.
And we'll see how different cultures balance your individual rights against this idea of the common good.
It's really a tour of how we define society. Because when you look at how a country handles eminent domain, you're looking at an X-ray of their values.
That's a great way to put it. You're seeing how they weigh the individual versus the collective.
Absolutely.
And the sources we have for this deep dive are just fascinating. We've got legal treatises, constitutional frameworks from literally every continent, historical records going way back to the Middle Ages.
And even some religious texts, which was a surprise to me.
Right. We're going really broad today to try and understand this thing from all sides.
We have to. The nuances are everything here because it affects everyone.
So here's the roadmap for the hour. We're going to start with the definition and the origins. Where did this idea even come from?
Then we'll get into the mechanics of what can be taken. And spoiler alert, it is not just land.
Not by a long shot. Then we have to get into the controversy, the whole public use definition in the U.S. that has caused so much heartburn and so many legal battles.
And then we'll take that global tour. We'll see how this all plays out in Europe, Asia, Africa, and beyond.
It's going to be a journey through time and geography. So let's unpack this. Let's start right at the beginning. Where did we get this term eminent domain? Because it sounds very fancy. It sounds like something a king would say while wearing a velvet cape.
It does sound regal, doesn't it? And that's actually pretty appropriate because it comes from Latin. To find the origin, we have to go back to 1625.
Okay, 1625. So let's set the scene. The world is in flux. The 30 Years' War is raging across Europe. Colonialism is really ramping up. The whole concept of the nation state is just starting to solidify.
Exactly. And in the middle of all this political chaos, we're looking at a Dutch jurist named Hugo Grotius.
Grotius. I feel like if you go to law school, that is a name you hear on, day one.
An absolute titan. He's often called the father of international law. He wrote this seminal legal treatise called De Jure Belli ac Pacis,
which translates to
On the Law of War and Peace.
some light reading for the beach.
An absolute page-turner for 17th century lawyers, I assure you. But this book was foundational for, well, for everything that came after in international law. And in this text, Grotius used the term dominium eminens,
Dominium eminence.
which translates to supreme ownership.
Supreme ownership. That sounds intense. It sounds like the final boss in a video game.
Yeah.
It implies that there's ownership, and then there's ownership with a capital O.
That is precisely the implication. The core theory, Grotius argued, was that the property of subjects is essentially under the supreme ownership of the state.
So the state is the ultimate owner of everything.
In his view, yes. He believed that the state, or those acting for it, could use, alienate, or even destroy property.
Destroy. Just blow it up.
If necessary. I mean, think about a city under siege. If you need to burn down a row of houses to create a firebreak or to deny cover to an invading enemy, the state has to have the power to do that.
Okay, that makes sense in an extreme emergency.
Yep. Right. And Grotius said this power applies not just in cases of extreme necessity, where even a private person might have a right to use someone else's stuff to survive, like stealing bread if you're starving, but for ends of public utility.
Public utility. Now, that's a very broad phrase.
It is. His argument was based on the social contract. He argued that the people who founded the civil society must have intended that private needs should give way to public needs.
So by living in a society, by accepting the protection of the state, you implicitly agree that your private property rights are secondary to the state's survival or utility.
You own it, yes, but the state owns it more.
That is a spooky concept. You own it, but we own it more. It fundamentally changes how you look at your deed. It's not a grant of absolute authority. It's more like a grant of permission that can be revoked.
Exactly. It's a conditional ownership.
But surely there was a catch. He didn't just say, the king can take your stuff, good luck, have a nice life.
I would hope not. That just sounds like tyranny. No, there was a very important caveat. Grotius noted that when this is done, the state is bound to make good the loss to those who lose their property.
Okay, so the pay me part of the equation has been there from the very beginning.
Theoretically, yes. The idea of compensation is baked into the original definition. It acknowledges that a wrong is being done to the individual for the sake of the group.
And that wrong has to be balanced by payment.
It turns it from what would be a theft into a forced sale.
Now, you mentioned earlier that this concept goes by a lot of different names, and I think that's important because it shows just how universal this is. If you're in the U.S. or the Philippines or Liberia, you call it eminent domain.
Right, and that's the terminology derived directly from that Latin dominium eminens. It really emphasizes the supremacy of the state's title.
But if you cross the Atlantic to the UK or go to New Zealand or Ireland, you'll hear compulsory purchase.
Which sounds a bit more transactional, doesn't it? We are purchasing this, and it is compulsory. It frames it almost like a commercial interaction where one party just happens to have all the leverage.
Right. I'm buying your house. You don't have a choice in the matter, but hey, I'm buying it. It feels very bureaucratic.
It does. Then if you go to Australia or Hong Kong, they use the term resumption.
Resumption.
Yeah.
Now, that is an interesting word choice. It implies they're just taking back something that was already theirs to begin with.
That's a very keen observation, and we will absolutely get to why Australia uses that specific word later. It has some deep legal implications about the Crown and how land was originally granted.
It suggests the government never really gave up full ownership. They just leased it to you.
That's the idea. Then in Canada, South Africa, and parts of Europe, you have expropriation. And in India and Malaysia, it's often just called land acquisition.
So regardless of the label, whether it's a purchase, a resumption, or an acquisition, the mechanism is the state stepping in. Let's talk about that mechanism. In the legal world, who are the players here? What are the terms?
Well, you have the condemner. That's the taker. Usually the government or an agency that's been empowered by the government.
And the legal act of taking the property is called condemnation.
Right.
Which is confusing because usually when I hear a building is condemned, I think it means it's, rat infested, falling down, and has a big red X on the door.
Right. That's the common use of the word condemned for safety reasons. But in this legal context, it just means seized via eminent domain. It could be a brand new, beautiful building. If the government condemns it, they're taking it.
And here's a crucial concept from the notes that I think our listeners need to understand. Fee simple.
Fee simple. This is absolutely critical to understanding the power dynamic here.
So what does that mean in plain English?
When the government takes your land, they typically take it in fee simple. And that's a legal term for absolute total ownership. Once the judgment is final and they've paid you, the condemner owns it completely. They own the dirt, the air rights, the mineral rights, everything.
Meaning they can do whatever they want with it.
Whatever they want. And this is a point that really surprises people. Let's say the government takes your land specifically to build a new school.
Okay.
They make a big speech about how the children need education. They condemn your farm, they pay you, and you move out. 5 years later, plans change, the budget dries up, they decide not to build the school after all.
Do I get my land back? Do they call me and say, hey, sorry, our bad, we didn't use it for that?
Almost certainly not, because they own it in fee simple. They can put it to uses other than those specified in the original eminent domain action.
So they could turn it into a park, a storage depot.
Or even sell it to a private developer.
Wow. So once it's gone, it's really, truly gone. There is no return policy on eminent domain.
It is absolute. And that leads us to the next big question. What exactly can they take?
Right. Section 2 of our deep dive. I think most of us picture land. We picture the widening of a road or a new government building, or maybe a military base.
And that is the most common use for sure. Real property, roads, utilities, government buildings. Historically, railroads were a huge, huge driver of this.
Oh, the railroad. They were the tech giants of the 19th century, weren't they?
They absolutely were. And they were very often granted eminent domain power to obtain land or easements to connect their rail networks, where you couldn't have a transcontinental railroad if one farmer in Nebraska could just say no and block the whole line.
That makes sense. It's an infrastructure necessity. You can't curve a train track around every stubborn landowner. It would be inefficient and probably dangerous.
Exactly. But the sources we looked at make it clear it's not just dirt and bricks. Governments can seize personal property, physical items.
Like my car, my office supplies.
In theory, yes, if there was a compelling public use for it. Think about wartime requisitions. If the Army needs trucks, they can take trucks. But where it gets really, really fascinating is when we get into intangible rights.
Intangible rights, what does that mean?
We're talking about things you can't touch. Contract rights, patents, trade secrets, even copyrights.
Wait, hold on, let's unpack that. The government can use eminent domain to seize a patent.
They can. If the government determines that a patent is necessary for public use, maybe a medical device during a pandemic or a specific piece of technology needed for national defense, they condemn that intellectual property.
That feels like a whole other level of power. It's one thing to take my yard, it's another thing entirely to take my idea. It feels so much more invasive.
It is. But the logic from the government's perspective is the same. Public necessity. If a company is sitting on a patent that could save thousands of lives, but they're refusing to produce the drug, the government has the theoretical power to step in.
But the example in the notes that really just blew my mind was the sports franchise.
Ah, yes. The Raiders. City of Oakland v. Oakland Raiders. This was 1982.
I'm a football fan, but I did not know about this particular legal battle. I know the Raiders move around a lot. Oakland, LA, back to Oakland, now Vegas.
A very nomadic team.
But I didn't know the courts got involved quite like this. What happened?
Well, the Oakland Raiders were planning to move the team to Los Angeles. And the city of Oakland, they did not want to lose them. They felt the team was part of the city's identity, a community asset.
Okay, I get that.
So the city tried to exercise eminent domain to seize the team itself.
They tried to seize the football team, like the players,
Yeah.
the brand,
The
the Mets.
the whole franchise, the legal entity. They argued that the team was a vital public asset, much like a park or a landmark or a museum.
That is an incredibly bold move. Did it work?
It went all the way to the California Supreme Court. And here is the absolutely wild part. The court ruled that taking a professional NFL franchise was within the purview of the public use constitutional limitation.
No way.
Yeah.
So they actually said, yes, a football team can be considered public property.
They did. They essentially said, yes, recreation is a valid public purpose, and a sports team provides recreation, so theoretically, you can condemn it.
But the Raiders aren't owned by the city of Oakland today. They're in Las Vegas. So what happened?
The taking was eventually blocked, but, and this is the key part, not because it wasn't a valid use of eminent domain. It was blocked because the court deemed it violated the Interstate Commerce Clause of the U.S. Constitution.
The Commerce Clause. Because the NFL is a national business.
Precisely. The NFL operates across state lines. If every city started seizing teams to keep them from moving, it would completely destroy the interstate commerce of the league. It would be chaos.
You couldn't run a league if Baltimore seized the Colts and Oakland seized the Raiders and so on.
Great. So the Commerce Clause saved the Raiders, not property rights laws. The eminent domain argument itself was found to be plausible.
That is just wild. It really stretches the definition of necessity to its breaking point. It implies that public entertainment is a public necessity.
It does. And that brings us to the other side of the equation, the compensation. We talked about Grotius saying the state must make good the loss.
Just compensation. That's the phrase in the U.S. Constitution.
And in theory, the idea is to make the owner whole, to put you in the same pecuniary position money-wise, as if the taking had never happened.
That sounds fair on the surface. If my house is worth $500,000, you give me $500,000. I take that money, I buy another house. No harm, no foul.
But worth is a very subjective term. In practice, courts usually limit this to fair market value at the property's highest and best use.
Okay, but what about all the other stuff? I mean, moving's expensive. What if I run a business out of that building? What about my goodwill, my reputation with the locals? What if all my customers know I'm on the corner of Main and First, and if I move, they won't be able to find me?
That is the pain point. And generally, incidental losses are not covered.
Really? So all that is just lost?
Your attorney's fees to fight the taking, usually not covered. Appraiser's fees, that's on you. Business goodwill, unless there's a specific state law or something like the Uniform Relocation Assistance Act applies, you don't get paid for the fact that your customer base won't follow you to a new location.
So you could literally lose your building, get paid the market rate for the bricks and mortar, but lose your entire livelihood because you can't replicate the business elsewhere, and the government just says, sorry, that's not our problem.
That is precisely what can happen. There are very rare exceptions. There was a case, Kimball Laundry Co., United States, that dealt with business losses in temporary takings.
A temporary taking.
The government took over a laundry during World War II, and the court said they had to pay for the trade routes, the delivery routes that they disrupted, and another, United States v. Pee Wee Coal Co., which covered operating losses during a WWII mine seizure.
But those are exceptions, not the rule.
They are. For the average person losing a shop or a home, the fair market value often feels very, very unfair. It covers the asset, but not the disruption, the emotional toll, or the lost momentum of a family business.
It seems like the make-whole theory is a nice idea that gets completely lost in the bureaucracy.
It is the gap between legal theory and economic reality.
Let's shift gears and look specifically at the United States. Because in the U.S., this battle over public use versus public benefit has been, well, it's been intense. It feels like this is where the philosophy really hits the road.
It has been one of the most contentious areas of constitutional law for decades. We start with the Fifth Amendment. It's very short. Nor shall private property be taken for public use without just compensation.
Just two requirements: public use and just compensation.
That's it. And as we said, Congress can do this directly or they can delegate it.
Right. So Congress can pass an act to take land directly, or they can delegate the power to private entities like public utilities.
So a power company can take land for power lines, or railroads can take land for tracks, or even, in some very specific cases, individuals.
But the real battle has been over that first phrase, public use. That definition has evolved, or maybe mutated over time.
That's a good way to put it. Originally, it meant what you think it means. Actual public usage. A road that everyone drives on. A fort that protects everyone. A post office.
Things the public actually touches or occupies.
Correct. But in the mid-20th century, we saw a massive shift. The government began taking property specifically to transfer it to private third parties.
And this is where it gets really tricky, taking my land to give it to a private developer.
Yes. It started with the concept of blight.
Blight. That sounds like a disease for a city.
In urban planning terms, it kind of is. The first big case was Berman v. Parker in 1954. This was in Washington, D.C. The Supreme Court allowed the government to take properties that were deemed blighted or impediments to development.
So we're talking about slums, basically.
Yes. The argument was that the area was dilapidated, unsafe, and was hurting the community as a whole. So clearing it all out was a public benefit, even if the land ended up being sold to private developers to build nice new apartments or shops.
Okay, I can see the argument there. Urban renewal. If a place is genuinely dangerous and falling apart, maybe the government does have a role to play. But it didn't stop there.
No, it expanded. The landmark case, the one that really got people angry, was Kelo v. City of New London in 2005.
I remember this. This was huge news at the time.
It was. In Kelo, the Supreme Court ruled that the government could take non-blighted property. We're talking about perfectly good, well-maintained homes. Suzette Kelo had a lovely little pink house. It wasn't a slum by any stretch.
And they took her perfectly good house to give it to a private developer.
Yes, the justification was purely economic development.
Not blight, not danger, just money.
Just money. The argument was that the new owner, a big pharmaceutical development, Pfizer was involved, would generate higher tax revenue and create more jobs. Therefore, it was a public benefit.
So if I have a modest little house and a developer wants to build a luxury hotel that would pay more in property taxes, the government can come in and say, sorry, the hotel is better for the public than your house is.
Under the Kelo decision, yes. The court essentially said that public use could be interpreted as public purpose or public benefit. They deferred to the city's judgment that the increased tax revenue was more important than Mrs. Kelo's pink house.
That feels like such a slippery slope. It basically means no property is safe if someone richer wants it and can convince the city they'll pay more taxes.
It was a very controversial 5-4 decision. Justice Sandra Day O'Connor wrote a stinging dissent. She said this decision made all property vulnerable.
What did she say?
Her words were, "The specter of condemnation hangs over all property. Nothing is to prevent the state from replacing any Motel 6 with a Ritz-Carlton, any home with a shopping mall, or any farm with a factory."
That is a chilling quote. What was the fallout from that decision?
It sparked an enormous backlash at the state level. People were absolutely furious. Many states rushed to pass new laws and even constitutional amendments restricting that kind of taking, specifically forbidding takings for economic development alone.
So they tried to close the door that the Supreme Court had just opened.
They did. It really struck a nerve with the public. It felt deeply un-American to many people.
Now, before we leave the U.S., I want to touch on one more technical thing that I found really interesting in the notes. Partial takings.
Yes, this is very common. Let's say the government needs to widen a highway. They don't take your whole farm. They just need to take a 20-foot strip along the front of your property.
Okay, so I keep my house, I keep my barn, I just lose the frontage.
Right, and obviously they have to pay you for that 20-foot strip they took. But taking that strip might lower the value of the rest of your land.
Oh, for sure. Maybe my house is now right up against a noisy highway. Maybe I lost my nice driveway and now I have a weird, awkward entrance.
Maybe the shape of the land is now strange and hard to farm.
Right.
Who wants to live 5 feet from a 6-lane freeway? It absolutely ruins the property value.
So what happens then?
That loss in value to the remaining property is called severance damages, and you're entitled to compensation for that as well.
Okay, that's good. So they pay me for the land they took and for the damage they did to the rest of it.
However, there is a little something called an offset.
Of course there is. There's always a catch.
If the new project increases the value of your leftover land, let's say that new highway builds an exit ramp right near your farm, suddenly making it prime commercial real estate, that benefit can be deducted from your damages.
So they could theoretically say, yes, we took your front yard, but we also made your backyard a gold mine, so we don't owe you anything for the damages.
In some jurisdictions, yes. If the benefit outweighed the damage, they can argue, we took your front yard, but now your property's worth $1 million because it's next to a new Walmart, so we're even.
Fascinating. It really does turn your home and your land into a complex math problem.
It does. It removes the emotion and just replaces it with appraisal tables and benefit calculations.
Let's jump across the pond, because the U.S. system is fundamentally based on English common law. So to understand where this all came from, we have to look at the United Kingdom.
We have to look at the roots of the law. And for that, we have to go way back to 1066.
1066 and all that. William the Conqueror.
Oh.
The Norman Conquest.
Right. When William conquered England, he seized virtually all the land in the country. He maintained absolute power over it and then granted fiefs to landholders who served him.
So originally, the king owned everything anyway. He was the ultimate landlord.
Effectively, yes. Everyone else was just a tenant. But the English have this long, proud history of pushing back against absolute power. And that brings us to the Magna Carta, Chapter 28.
The Magna Carta comes up in everything, doesn't it?
It's just that foundational. It was a check on this kind of power. It required immediate cash payment for expropriations. It said, and I'm paraphrasing, no constable or other royal official shall take corn or other movable goods from any man without immediate payment.
So, cash on delivery for land seizures. No IOUs from the king.
Basically. But there are some amazing little historical curiosities in the UK legal record. For instance, the Commissioners of Sewers in Lincolnshire in 1427.
The Commissioners of Sewers. That sounds like the absolute worst job title in the Middle Ages.
A very powerful group, apparently. They were granted the power to take land without any compensation.
Ouch. I guess drainage was considered so vitally important that property rights just went out the window.
It was an early outlier. By the 16th century, parliamentary takings generally did require compensation. And here's a fun detail. For a very long time, the common practice in the UK was to pay the assessed value of the land plus a 10% bonus.
A bonus? Why on earth would they pay a bonus?
It was a recognition of the compulsory nature of the sale. We are forcing you to sell, so here is a little extra for the trouble. A solatium for the inconvenience.
That is incredibly civilized.
Here is the fair market value, plus a tip for inconveniencing you. What happened to the 10% bonus?
It was eliminated as the voting franchise expanded? Wait, what does voting have to do with it?
Well, think about who was sitting in Parliament in the 18th and early 19th centuries. It was landowners. When only landowners could vote, Parliament, which was made up of landowners, was very generous to other landowners. If you take my land, you better pay me a handsome bonus.
Ah, it was self-interest at work.
Exactly. But as non-landowners got the right to vote, the political will to give extra bonuses to property owners just evaporated. The general public didn't want their tax money going to extra bonuses for the rich, so the bonus disappeared.
That is a perfect example of how politics directly shapes the law.
It is. Another little difference is the use of juries. In the U.S., we don't typically use juries for these valuation cases anymore. It's usually a judge or a special commission. But the U.K. used juries for valuation well into the 20th century, like in the Attorney General V. de Keyser's Royal Hotel Ltd. case in 1919.
So today, in the modern UK, it's all called compulsory purchase.
Yes. And if the price isn't agreed upon, it goes to what's called the upper tribunal.
That sounds very Harry Potter. The upper tribunal will now decide your fate.
It does a bit. And Scotland, as is often the case, has its own distinct legal history. Compulsory purchase there really took off during the Victorian railway mania.
The trains again.
Mm.
It really seems like trains are the driving force of modern property law in the 19th century globally.
They absolutely were. They reshaped the physical and the legal landscape. The sheer amount of land needed for a national rail network forced every country to standardize and codify how they took land. You couldn't have a patchwork, town-by-town system.
Let's broaden our horizon now. We've done the West. Let's look at Asia, because the scale there, it's just completely different.
The scale is immense, and the prime example has to be China.
We have to talk about the Three Gorges Dam.
The Three Gorges Dam. It is the ultimate example of eminent domain on a massive, almost unimaginable scale. To build that dam, the Chinese government displaced over 1.3 million people.
1.3 million. That's the population of a major city. That's bigger than San Francisco or Dallas.
Entire towns, ancient cities, ancestral villages, all of it now underwater. This just highlights the incredible social and environmental cost of these large-scale public interest projects.
How does the legal framework even work there? I'm assuming it's not quite like the U.S. system with court battles over fair market value.
The term they use is requisitions. It's constitutionally permitted for the public interest with compensation. But for a long time, the compensation was heavily criticized as being insufficient, especially for rural farmers who were moved into high-rise apartments in cities where they couldn't farm.
So they lost their land and their entire way of life.
Exactly. But there have been reforms. In 2019, there was a major amendment to the land administration law. It specifically aimed to guarantee greater financial security for displaced farmers. It spells out much more detailed guidelines for compensation and resettlement.
So it shows that even in a system like China's, there is a growing pressure to address the human cost of these massive takings. You can't just displace 1 million people without significant consequence.
Right. There's a recognition that the process needs to be fairer.
Then we have India. And India's story is really interesting because of the constitutional gymnastics they've gone through over the right to property.
Gymnastics is the perfect word. Originally, in the Indian Constitution, property was a fundamental right. It was in Articles 19 and 31.
So it was protected on a highest possible level, like free speech or freedom of religion.
It was. But then came the 44th Amendment in 1978.
What happened?
They just deleted the right to property from the list of fundamental rights.
They just diluted it. You can do that.
They did. It's now Article 300A. It's just a constitutional right, not a fundamental one.
What is the practical difference between a constitutional right and a fundamental right?
The difference is huge. It means that if a legislature makes a law that deprives a person of property, that law is not unconstitutional, provided there is some legal authority for it. You can't go to the Supreme Court claiming a violation of your fundamental rights in the same way you could before.
Why on earth did they do that?
It was largely to facilitate land reform and redistribution. The government at the time felt that strong property rights were blocking necessary social changes, like breaking up large feudal estates and helping the landless poor. But fast forward to the modern era and you get the Lannar Act of 2013.
Lawyer.
It's a mouthful. The right to fair compensation and transparency in Land Acquisition, Rehabilitation, and Resettlement Act.
Okay, but transparency and rehabilitation sound like promising words to have in the title.
It was a big step. It replaced a colonial-era act from 1894. That's a long time to operate under an old law. The focus of the new act shifted to fair compensation and actually rehabilitating the people you displace. But there is a massive tension in India right now.
Between what?
Between the liberalization of the economy, setting up these huge special economic zones or SEZs for industry, and the rights of farmers. These SEZs require enormous amounts of land.
And I'm guessing farmers don't want to give up their land.
Exactly. There have been huge protests, and there is this serious debate happening in India right now about whether property needs to be reinstated as a fundamental right to protect the little guy against powerful corporate interests who are working with the government.
It's the classic development versus displacement dilemma. Do you build a factory that creates 10,000 jobs, or do you save the 500 farms that have been there for generations?
Everywhere you look in the world, that is the core question.
Let's move to Africa, specifically Zimbabwe.
No.
This is a case where eminent domain intersects with history, colonialism, and racial justice in a very raw and powerful way.
Yes, so the historical context here is absolutely vital. In the 1980s, shortly after independence, about 4,400 white Rhodesians owned 51% of the arable land in the country.
That is a staggering statistic. 51% of the land owned by such a tiny group.
It was the direct legacy of colonialism, and it was seen as unsustainable and unjust. So under Robert Mugabe, starting in the 1990s, the government used compulsory purchase extensively. They called it the Land Reform Program.
And the goal was redistribution.
Yes, to redistribute land to dispossessed Black Zimbabweans. The government argued this was necessary to correct historical injustices. They viewed the colonial-era land ownership itself as a theft that needed to be reversed.
But the compensation issue, that was the big sticking point, right? It caused a huge international incident.
It was a major geopolitical flashpoint. The process was often chaotic and sometimes violent. Compensation was delayed for years or not paid at all. The economy suffered massively as agricultural production just collapsed. It became a global cautionary tale about how the process of reform matters just as much as the goal.
But there is a recent update in the notes. Something happened in 2022.
Yes. In 2022, the Zimbabwean government finally agreed to pay $3.5 billion in compensation to the white farmers who lost their land.
$3.5 billion. That is a huge sum for a country like Zimbabwe.
It is. It's a recognition that while the purpose of the takings might have been historical correction, the process still required a financial settling of accounts. It's an attempt to finally close that chapter and normalize relations with the international community.
That brings us to Oceania. Australia. You mentioned earlier they use that unique word, resumption.
Yes, resumption.
Yeah.
And it reflects the legal fiction, or a legal reality, depending on your point of view, that all land in Australia was originally owned by the Crown before it was sold or granted to individual.
So when the government takes it, they are just resuming possession.
I'll just take that back now, thank you. It sounds so polite.
It does. So how does it work there?
The Australian Constitution, in Section 51, requires acquisitions to be on just terms.
Just terms. Sounds friendly. Similar to just compensation.
It is. But there's a fascinating and controversial legal loophole involving the difference between an Australian state and an Australian territory.
A loophole. I love a good legal loophole.
The Commonwealth, which is the federal government, is limited by the Constitution to taking land for specific public purposes. But the territories, well, there was a famous case in the Northern Territory.
Go on.
The Lands Acquisition Act 1998 in the Northern Territory allowed the minister to acquire land for any purpose whatever.
For any purpose whatever. That sounds incredibly broad. That sounds like because I feel like it today.
It is about as broad as it gets, and the High Court of Australia upheld it. This became incredibly controversial because it was used to extinguish native title interests.
Native title, so indigenous land rights.
Yes. By resuming the land for any purpose whatever, The government could effectively wipe out the native title claims on that land. Justice Michael Kirby, in his famous dissent, called it assisted theft and blasted the law for its lack of any public purpose limitation.
Wow. That is a stark reminder of how these laws can be weaponized against specific, often marginalized groups. If the government can take land for any purpose, then nobody's land is safe, but especially not the people with the least political power.
Absolutely. The definition of public purpose matters immensely. If you remove that guardrail, you just have raw power.
Let's loop back to Europe. We talked about the UK, but continental Europe has a slightly different flavor. They have the European Convention on Human Rights, the ECHR.
They do, and that adds another layer. You have Article 8, which is the right to respect for one's home, and Protocol 1, Article 1, which guarantees the peaceful enjoyment of one's possessions.
That sounds lovely. Peaceful enjoyment. It sounds like something from a spa brochure.
It is. But of course, there are exceptions for the public interest and for things like taxes. But generally, the ECHR provides a strong layer of protection for property owners. However, history gives us some very dramatic exceptions.
We absolutely have to talk about the Renault story in France.
This is one of the most dramatic examples you'll ever find of punitive expropriation.
Punitive as in punishment.
Exactly. As punishment. The year is 1945. France has just been liberated from Nazi occupation. General Charles de Gaulle is in charge. He issues an order to expropriate the entire Renault car company from its founder, Louis Renault.
Why? Did the government need the factory to build tanks or something?
No. It was because of accusations that Louis Renault had collaborated with the Nazi occupiers during the war.
So they took his entire company because he was accused of being a collaborator.
Posthumously, yes. Louis Renault actually died in prison before he could be tried. But the state nationalized the company, turning it into the Régie Nationale des Usines Renault. And this is the key. They did it without any compensation.
Without compensation. So it wasn't a forced sale. It was a penalty. It was a fine of 100% of his company.
Precisely. It wasn't, we need this for the public good. It was, you don't deserve to own this anymore. That is a very, very different use of the power. It was an act of national purification as much as it was an economic one.
What about Italy?
Italy makes an interesting distinction between esproprio, which is taking a specific piece of property, and nazionalizzazione.
Nationalization.
Right, taking a whole industrial sector. For example, in 1962, they nationalized the entire electric power sector. They just took the whole grid. But Italy also has this unique concept in its constitution called social solidarity.
Social solidarity. That sounds very European.
It does, doesn't it? The Constitution explicitly binds citizens to duties of political and economic solidarity. And this can be used as a justification for takings. The idea is that you are part of a society, and sometimes you have to take a hit for the team.
So it's less, this is my castle and I'll defend it to the death, and more, we are all in this village together and the village has needs.
That's a great way of putting it. And in Germany, their basic law, in Article 14, is very clear. Expropriation is only permitted for the public good.
We have covered legal, political, and historical perspectives. But there is one more lens in our stack of sources, and that's religion.
Yes. It's fascinating to see how theology tackles this, because usually we think of religion as dealing with the soul, not with real estate law.
Specifically, we're looking at Catholic social teaching.
We are. We're looking at Pope Paul VI's encyclical Popularum Progressio, which was written in 1967.
What did the Pope have to say about eminent domain?
He explicitly allowed for the expropriation of landed estates if it's required for the common good or if the community's needs demand it.
Really? The Catholic Church is on board with this.
It is. The argument from that perspective is that private property is not an absolute godlike right that trumps all other considerations. If the community is starving and you are sitting on a massive unused estate, the moral imperative, not just the legal one, might be to redistribute that land.
So in that view, eminent domain isn't just a state power. It could be seen as a moral tool.
Potentially, yes. It frames ownership as a form of stewardship. You hold it, but you hold it within the context of a community. If you hoard it to the detriment of that community, you could be seen as forfeiting your moral right to it.
So what does this all mean? We have gone from 17th century Dutch philosophy to modern Chinese dams, from the seizure of French car factories to the attempted seizure of American football teams.
It is a lot to process, but I think the synthesis is clear. There is this universal tension
Between the individual and the state.
between the individual's castle and the community's needs. Whether you call it resumption or requisition or condemnation, every single society has realized that sometimes the mine has to yield to the hours.
It's the price of civilization in a way. If we want roads and hospitals and dams and power grids, someone somewhere has to move.
But the danger, as we saw in the Kelo case or the native title cases in Australia, is who gets to define need. Who decides when the hours is actually just someone else's profit?
That is the scary part, and here's where it gets really interesting for the future.
Oh.
We have been talking about physical things, land, factories,
Yeah.
football teams, but we are all moving into a digital world.
We are, for sure.
So here's a final provocative thought for you listening. As we move into an era of digital assets, cryptocurrency, intellectual property, will the definition of public use expand even further?
That is the million-dollar question.
If the government can take a patent for the public good, could they one day seize a blockchain because it's become critical infrastructure? Could they seize an algorithm that runs the economy? If public use evolves to mean public economic stability, what, if anything, is safe?
If the government can take a sports franchise because it's good for public morale, could they take over a social media platform because it's become the public square?
Exactly. The very definition of property is changing right under our feet. And you can bet the definition of eminent domain will change right along with it.
It's definitely something to watch closely.
Thank you for joining us on this deep dive. It's been a pleasure exploring the very fuzzy boundaries of ownership with you.
Always a pleasure.
Until next time, keep asking questions.
And maybe read the fine print on your deed.
See you next time.